Welcome back to the Self-Care Zone podcast. My name is Brett, and today we're starting a new series that every business leader, manager, and HR professional in Australia needs to pay attention to. We're talking about psychosocial risk. And if that term makes your eyes glaze over or sound like HR jargon that you can ignore, I need you to lean in right now because the legal landscape has fundamentally changed. And what was once seen as a nice to have is now a legal obligation with serious consequences. This episode is called Psychosocial Risk, the new legal minefield. And we're diving into personal liability, prosecutions that are already happening, claims trends that should terrify every organization, and why we didn't know is no longer a defense. If you're in any kind of leadership position or you're not taking psychosocial safety seriously, you're playing Russian roulette with your career, your organization's reputation, and potentially your personal assets. So let's talk about why. First, let's get clear on what we're actually talking about, because psychosocial risk is often misunderstood or dismissed as fluffy well-being stuff. Psychosocial risks are factors in work design, management, and the social environment that can cause psychological or physical harm. We're talking about things like excessive workload, job insecurity, lack of role clarity, poor support from management, bullying and harassment, exposure to trauma, low control over work, conflicting demands, poor workplace relationships, inadequate recognition, and organizational injustice. These aren't just things that make work unpleasant. These are hazards, just like exposure to chemicals, working at heights, or operating machinery without guards. They're risks that cause serious harm. And under work health and safety legislation across Australia, employers have the same duty to manage psychosocial risk as they do to manage a physical risk. That's not my opinion, that's the law. And it's being enforced with increasing frequency and severity. Work health and safety laws have always required employers to eliminate or minimize risks to health and safety so far as reasonably practical. This has always included psychological health, not just physical safety. But for years, enforcement focused primarily on physical injuries, falls from heights, machinery accidents, chemical exposure, things that you could see and measure easily. Psychosocial risks are acknowledged but rarely prosecuted. Organizations could largely ignore them without consequences, but that's changed dramatically. In recent years, regulators have made it explicitly clear that psychosocial hazards are a priority. WorkSafe Australia has published comprehensive guidance. State regulators have launched campaigns, and most importantly, they're taking enforcement action. The message is unambiguous. You must identify, assess, and control psychosocial risks. This is not optional. This is not aspirational. This is a legal requirement. So why the sudden focus? Why are regulators cracking down now? First, the evidence is overwhelming. We know that psychosocial hazards cause serious harm: depression, anxiety, PTSD, cardiovascular disease, musculoskeletal disorders. The link between workplace psychosocial risks and physical and mental health harm is scientifically established. Second, the scale of the problem is massive. Psychological injury claims are increasing year on year. They're more expensive than physical injuries, with longer recovery times and higher compensation costs. We talked about this in our burnout series, billions of dollars in costs annually. Third, workers are less willing to accept harmful conditions silently. There's increased awareness of rights, reduced stigma around mental health, and more willingness to speak up or make claims. And fourth, regulators are under pressure to do something. The old approach of focusing only on physical safety, while the psychological harm runs rampant, is no longer politically or ethically acceptable. So the enforcement environment has shifted, and organizations that haven't noticed are about to get a very expensive wake-up call. Now let's talk about what's actually happening. Not theory, not what might happen, what is actually happening right now in Australian workplaces and courts. In 2023, a Victorian aged care provider was prosecuted and convicted for failing to manage psychosocial risk after an employee developed PTSD from workplace bullying and harassment. The organisation was fined significantly. More importantly, they were publicly named. Their reputation took a hit that will affect recruitment and retention for years. A Queensland healthcare organisation faced prosecution after an employee experienced psychological injury from sustained excessive workload and inadequate support. The regulator found the organisation had failed to identify and control known psychosocial hazards. Multiple organisations have been issued improvement notices and prohibition notices related to psychosocial hazards. These are formal regulatory interventions that go on public record and trigger mandatory reporting to boards and senior leadership. There are many more investigations underway, compliance notices issued, and enforcement actions in progress. The era of psychosocial risks being ignored is over. So let's look at the claims data, because this is where the financial reality becomes crystal clear. Psychological injury claims are increasing at a rate significantly higher than physical injury claims. In some jurisdictions, they now represent 10 to 15% of all workers' compensation claims. But here's the really concerning part. The average cost of a psychological injury is much higher than a physical injury claim. We're talking average costs of $100,000 to $150,000 per claim, with some claims exceeding $500,000. The duration of the claim is also much longer. Physical injuries might keep someone out of work for weeks or maybe a few months. Psychological injuries often involve months or years of absence, treatment, and recovery. And the success rate of claims is high. When workers make psychological injury claims related to workplace psychosocial hazards, they're winning those claims at increasing rates because the link between workplace factors and psychological harm is well established. For organizations, this means several things. Your workers' compensation premiums will rise with claims history. Each claim costs enormous amounts of indirect compensation. There are indirect costs in lost productivity, recruitment, and reputational damage. Multiple claims establish patterns that attract regulatory attention. Claims data is discoverable in prosecutions and civil litigation. You cannot afford to ignore this from a pure financial perspective, let alone from a legal or ethical perspective. Now, here's where it gets really serious for individuals in leadership positions. Under WHS legislation, officers of the organisation, directors, executives, senior managers, have personal duties to exercise due diligence in ensuring the organisation meets its work health and safety obligations. Due diligence means that you must acquire and keep up-to-date knowledge of work health and safety matters including psychosocial hazards and risks. Understand the hazards and the risks associated with your organization's operations. Ensure the organization has appropriate resources and processes to manage risks. Ensure the organization has appropriate information, training, and supervision. Ensure the organization has appropriate processes for receiving information about hazards, incidents, and risks, and for responding appropriately. And verify that these resources and processes are actually being used and are effective. If you're an officer and you don't have any of these done, you're in breach of your personal duty. And the penalties for individuals can include substantial fines and even prison for cases of serious harm. Let me be really clear about what this means. If you're a CEO, director, or senior executive, and there's a serious psychological injury in your organization linked to psychosocial hazards that you should have known about and failed to address, you can be personally prosecuted. Your defense of, I didn't know, or that was HR's job, or I was focused on the business, won't work. The law requires you to know. That's what due diligence means. And in serious cases, there's potential for criminal prosecutions if there's recklessness. If you are aware of a serious risk and did nothing, that's not just a fine, that's potential criminal liability. This should genuinely concern every person in a leadership position. Your personal liability is real and is being enforced. There used to be some plausible deniability around psychosocial risks. We didn't realize this was a legal requirement, or we thought it was just well-being. We didn't know the risks were that serious. That defense is gone. Not just gone, completely gone. Here's why. First, the guidance is extensive and publicly available. WorkSafe Australia has published detailed codes of practice on managing psychosocial hazards. Every state regulator has guidance materials. Industry bodies have resources. If you haven't read them, that's a choice, not an excuse. Second, there's been substantial media coverage and industry decision about psychosocial hazards and risks and the legal obligations. Conferences, webinars, articles, regulatory campaigns. The information is everywhere. Third, regulators have been clear about their enforcement intentions. They've announced that psychosocial hazards are a priority. They've published enforcement strategies. They've communicated their expectations. Fourth, the link between psychosocial hazard and harm is well established in scientific literature. You don't get to claim ignorance of something that's been well known for decades. And fifth, courts and regulators are explicitly rejecting "we didn't know" as a defense. They're saying that reasonable due diligence would have informed you of your obligations. Your ignorance is not an excuse. It's evidence of your failure to exercise due diligence. So if you're a leader thinking we'll deal with this when we get a claim, or surely this really doesn't apply to us, and that no one's really going to enforce this, you are wrong, dangerously wrong. Now let's talk about what organizations are actually getting wrong, because misunderstanding these mistakes help clarify what you need to do differently. Failure one, treating this as a tick box exercise. Some organizations conduct a survey, write a report, and think they're done. But the law requires ongoing risk management. Identify, assess, control, and review. If you did a survey 2 years ago and have done nothing since, you're not compliant. Failure 2, not acting on known issues. This is the big one. Organizations often know about problems. Exit interviews mention excessive workload. Staff surveys show poor management support. There are complaints about bullying, but nothing changes. That knowledge without action creates liability. If you knew about risks and failed to control them, that's a breach. Failure 3, relying on individual resilience instead of fixing hazards. Offering employees resilience training or mindfulness apps while leaving the underlying hazards in place does not meet your legal obligations. Your duty is to eliminate or minimize the hazards, not to make workers better at tolerating harmful conditions. Failure 4, inadequate investigation of incidents. When there's a psychological injury or a complaint or an incident, some organizations just do a brief investigations that are more about protecting the organization than understanding what happened and preventing the reoccurrence. That doesn't satisfy your obligation and creates evidence of inadequate response. Number 5, no genuine consultation with workers. WHS law requires consultation with workers about hazards and control measures. Running a survey without meaningful engagement doesn't satisfy this. Workers need genuine opportunity to participate in identifying risks and developing controls. Failure 6, inadequate training and awareness. Managers and workers need to understand psychosocial hazards, how to identify them, and what to do about them. If your training focuses only on physical safety, you're not meeting your obligations. And failure 7, poor documentation. If you can't demonstrate what you've done to identify, assess, and control psychosocial risks, you can't prove that you've met your obligations. In a prosecution or a claim, what's not documented might as well not exist. Psychosocial risk management also intersects with other legal obligations that organizations have. Think anti-discrimination and harassment laws. If you're not managing psychosocial hazards like bullying and harassment, you're likely also breaching those laws. Duty of care in common law. Organizations have a duty of care to employees. Failure to address known psychosocial risks can create civil liabilities beyond WHS prosecutions. Directors' duties. Officers have duties under corporations law to act with care and diligence. Ignoring psychosocial risks could constitute a breach of these duties. Privacy obligations. When managing psychosocial risks, you're often dealing with sensitive information. You need to balance transparency with privacy, which requires care and expertise. The point is, psychosocial risk is not isolated. It connects multiple areas of legal obligations. Getting it wrong has cascading consequences. Some organizations think they can apply their physical safety approach to psychosocial risks. We're good at safety, so we'll just do the same thing. But psychosocial risks are different in important ways. They're invisible. You can see someone is working at heights without a harness. You can't see someone experiencing chronic work stress until they're seriously unwell. They're subjective and context dependent. What constitutes excessive workload depends on the individual, their resources, their other demands. There's no simple measurement like decibels or chemical exposure limits. They involve complex interpersonal dynamics, bullying, poor support, inadequate recognition. These involve relationships and organizational culture. They're harder to identify and control than physical hazards. They're often systemic. Physical hazards can be localized, a faulty machine, a dangerous work area. Psychosocial hazards like excessive job demands or low control are often embedded in how work is designed across the entire organization, and they're emotionally charged. Addressing psychosocial hazards often means confronting uncomfortable truths about leadership, culture, and organizational practices. People get defensive in ways that they don't about physical safety. This means that you can't just replicate your physical safety approach. You need strategies specifically designed for psychosocial risks. So we've established the legal obligation, the enforcement reality, the claims trend, and the personal liability. Now, let's talk about what this means practically. At a minimum, WHS law requires you to identify psychosocial hazards in your workplace. This means systematically looking at the factors that could cause psychological harm: excessive demands, low support, bullying, trauma exposure, job insecurity, and more. Assess the risks that those hazards create. How likely is harm? How severe could it be? Who's exposed? How often? This requires more than casual observation. It requires proper assessment processes. Implement control measures to eliminate or minimize those risks so far as reasonably practical. The hierarchy of controls applies. Eliminate the hazard if possible. If not, then minimize it through substitution, isolation, engineering controls, administrative controls, and finally, PPE, which for psychosocial risks might be things like an EAP service. Review your control measures regularly to ensure that they're effective. This isn't a one and done. This is an ongoing cycle of risk management. Consult with workers throughout the process. They need meaningful opportunities to participate in identifying hazards and developing controls. Provide information, training, and supervision so that workers and managers understand psychosocial hazards and how to manage them. Keep records that demonstrate you've done all of the above. Documentation matters enormously in demonstrating compliance. This is not optional. This is what the law requires, and failure to do these things creates liability. Some organizations balk at the investment required for proper psychosocial risk management. We don't have the budget for this. We're too busy. We'll get to it eventually. But let's look at the actual costs. Time and resources for hazard identification and risk assessment. Development and implementation of control measures. Training for managers and workers. Ongoing monitoring and review. Possible need for external expertise or tools. This might cost tens of thousands to low hundreds of thousands, depending on organization size and complexity. It's not trivial, but it's manageable. The cost of non-compliance, prosecution penalties, tens to hundreds of thousands of dollars for the organization, plus potential personal fines for officers. Workers' compensation claims, $100,000 to $500,000 plus per claim. Legal costs defending prosecutions or claims. Increased insurance premiums. Productivity loss from psychological injuries. Recruitment costs from turnover. Reputational damage affecting ability to attract talent and win contracts. Potential civil damages in common law claims. The cost of non-compliance is exponentially higher than the cost of compliance. This is not even a close call financially. Beyond the legal and financial costs, there are significant reputational risks in doing this wrong. When organizations are prosecuted for failing to manage psychosocial risks, it's public. It's reported in media. It's searchable online. It affects how you're perceived as an employer. In industries like community services, healthcare, and education, where you're recruiting from competitive talent pools, your reputation as an employer matters enormously. If you're known as an organization that burnt out your workers or failed to protect them from psychological harm, good luck recruiting quality candidates. And in some sectors, your clients and funding bodies care about this too. Government contracts increasingly require evidence of WHS compliance, including psychosocial risk management. If you can't demonstrate this, you might be ineligible for certain contracts. Reputational damage can take years to repair and cost far more than prevention ever would have. So what does actually taking this seriously look like? At the board or executive level, include psychosocial risks on the risk register alongside other strategic risks. Ensure there's a clear governance and structure with assigned responsibilities. Allocate appropriate resources, budget, time, and personnel. Receive regular reports on psychosocial hazards, incidents, and control measures. Ask questions and demand evidence of compliance. Model the behaviors and the culture that you want to see. At the management level, understand your obligations and the psychosocial hazards in your area. Participate in hazard identification and risk assessment. Implement control measures within your sphere of influence. Create psychological safety for workers to raise concerns. Respond appropriately when issues are raised, and monitor your team's well-being and workload. At HR and WHS level, develop and implement systematic psychosocial risk management processes. Provide guidance and support to managers. Coordinate training and awareness building. Monitor trends and escalate issues appropriately. Maintain documentation of risk management activities. Liaise with regulators and insurers if needed. At the worker level, participate in hazard identification and the consultation process. Raise concerns when you become aware of psychosocial hazards. Follow safe work procedures and practices. Support colleagues experiencing difficulties. Engage with training and information provided. Everyone has a role. It's not just an HR issue or a compliance issue. It's an organizational responsibility that requires engagement at all levels. Now, I know what some people might be thinking. This sounds like a lot. Do we really need to do all of this? Is it really being enforced? Yes, absolutely yes. And let me tell you why ignoring this is genuinely dangerous. Some organizations are taking a wait and see approach, waiting for more prosecutions, waiting for clearer guidance, waiting until they get an incident or a claim, waiting until they have more resources. But this is a terrible strategy. By the time you get prosecuted, the harm has already happened. The damage is done to the affected worker, to your reputation, to your finances. You're now in reactive crisis mode instead of proactive risk management. By the time you get a serious claim, you're already looking at substantial costs, and that claim will likely trigger regulatory attention. Now you're dealing with both the claim and the potential investigation or prosecution. The guidance is already clear. If you're waiting for more clarity, you're making a choice to remain ignorant of obligations that are already well defined. And the enforcement is happening now. This isn't theoretical future risks. Regulators are investigating and prosecuting psychosocial risk today. Waiting is not a strategy, it's negligence. If you're in a leadership position, director, CEO, senior executive, your personal stake in this are high. Your professional reputation is at risk. Being prosecuted personally for WHS breaches or being an officer of an organization prosecuted for psychosocial risk failures will follow you for your career. Your financial assets are at risk. Personal fines can be substantial. In the most serious cases, there's potential for directors and officers' insurance to be voided if there's been reckless disregard for obligations. And in very serious cases involving recklessness and substantial harm, there's theoretical risk of imprisonment. This is rare and requires extreme circumstances, but it exists in the legislation. But beyond legal risk, there's also moral responsibilities. If workers in your organization experience serious psychological harm because of hazards that you could have controlled, you need to be able to live with that. The human cost is real. Taking this seriously is not just about avoiding legal liability. It's about taking care of the people whose well-being you are responsible for. If you're realizing that your organization isn't doing enough, the good news is you can start now. The first step is education. Board members, executives, managers need to understand what psychosocial risks are, what the legal obligations are, and what the consequences of non-compliance are. This episode is a start, but you need a more comprehensive understanding. The second step is assessment. Where are you now? What processes do you have? What's documented? What's the gap? An honest stocktake of current state is essential. The third step is developing a plan. Based on your assessment, what needs to happen, in what sequence, with what resources, whose responsibility, and what are the timelines. The fourth step is implementation. Actually doing the work of identifying hazards, assessing risks, implementing controls, consulting with workers, providing training, and documenting everything. And the fifth step is ongoing review and improvement. This is not a project with an end date. This is an ongoing risk management function that needs to be embedded in how you operate. If you need support in any of this, education, assessment, planning, implementation, that's exactly the work that I do with organizations through the self-care zone. I help organizations understand their psychosocial risk obligations, assess current state, develop compliant risk management processes, train managers and workers, and embed psychosocial risk management into operations. This includes practical support like facilitated hazard identification, risk assessment frameworks, control measure development, policy and procedure development, and training programs that meet legal requirements. Because complying with psychosocial risk obligations isn't about avoiding prosecution. It's about creating workplaces where people can do meaningful work without being harmed in the process. If you want to explore what this support could look like for your organization, reach out. Send me an email to info@theselfcarezone.com or visit theselfcarezone.com. Because the legal landscape has changed. Your obligations are clear. Enforcement is real. And the time to act is now, not after something goes wrong. So that's where we're going to leave it today. Psychosocial risks as the new legal minefield. Your compliance is no longer optional. Why personal liability is real and why we didn't know doesn't work as a defense anymore. If this episode has made you uncomfortable, good. That discomfort is information that you need to pay attention to this. If you're in leadership and you're not comfortable your organization is managing psychosocial risks appropriately, that's a risk that you can't ignore. Your personal liability is real. Your organization's exposure is real. And the human cost of getting this wrong is real. Next episode, we're diving into the 14 psychosocial hazards. What are they? How to identify them? And why no one wants to own them. Because you can't manage risks that you don't understand. Share this episode with every leader in your organization, with your board members, with your executive team, with your managers. Everyone needs to understand what's at stake here. So take care of yourselves and each other and take care of your legal obligations.